Thank you.
Good morning.
Good morning.
Please state your name.
Stephanie Murphy.
How do you spell first and last name?
Stephanie is Stephanie. Murphy is Murphy.
And what is your profession?
I'm an attorney.
How long have you been an attorney?
This is my 23rd year as an attorney and actually in the Sarasota-Bradenton area.
And are you with a firm, sole practitioner? What do you do?
My husband and I have our own firm, and I've had that firm for 16 and a half, 17 years. Before that, I was at a larger firm in Sarasota.
And what is your topic of law that you practice?
I practice family law, which is generally comprised of divorce, custody cases, or what used to be called custody cases, and adoption cases.
Okay. I want to ask you about Doug Benefield. Did he hire you?
He did.
And approximately when did he hire you?
He hired me in March 2018. He came for a first consultation on the 13th. He hired me on the 14th of March 2018.
And what was the purpose of your duties to begin with?
Initially, the purpose of hiring me was to draft a letter to Ashley Benefield, who was pregnant with their child at the time, which I did. I drafted a letter and sent it the day after I was retained. But the purpose of that letter was actually just to initiate.
Relevance. She stated that she sent the letter, that she was retained to send the letter. Now going to explain something.
Okay, overruled.
What was the purpose of the letter?
The purpose of the letter was to open the door for discussion about Doug's participation in the upcoming birth of their child, but also to advise that if she did not feel comfortable with him being present at the birth, he was respecting her need for space.
And when did you send that letter?
I sent that letter on March 15th at 9:59 in the morning by email to Ms. Benefield.
Okay. And did you receive a response to that letter?
I did not receive a response directly from Ms. Benefield. She checked herself into Tampa General the next day to start induction.
Sustained.
So when was the child born?
Well, the child was born early. She was born on March 19th, I believe, is when she was finally born.
And you said early. How many weeks early was that?
Well, the child was originally scheduled, or her due date was April 8th. So I think
Sustained.
Okay. So you said you never received a response
not from Ms. Benefield.
from Ms. Benefield about the letter.
Correct.
And to your knowledge, did Doug ever receive a response to that letter?
To my knowledge, he did not receive any response from Ms. Benefield or anyone on her behalf.
Okay. And I think you might have said this, but the child was born on what day?
She was born on the 19th of March.
Okay. And at the time the child was born, did you or Doug know that the child was born?
No, gosh, we didn't know for a good 5 or 6 weeks after she was born.
Okay. And how did you find out that the child was born?
I actually found out because I had been monitoring the docket for Manatee County court system, just because there had been no response. And so on May 6th, I saw that Ms. Benefield had filed a petition for protection against domestic violence on, I think it was April 23rd. So about 2 weeks prior to me finding out, she had filed the petition. And in that filing, there was, she identified the birth date of the child, as well as I think the child's name, which is the first time we learned about that too.
Okay. And you said she filed a petition for, what did you call it?
It's a petition for protection against domestic violence. So it's an injunction. A lot of people refer to it as a restraining order, but it wasn't granted as an injunction at the time.
Okay. So when, just for knowledge of people that may not know, when someone does a request for an injunction, what is sort of the procedure that it needs to go through?
So a person who files a petition for an injunction, they file it at the courthouse in the clerk's office, and then that gets sent up to the judge, usually a family law judge who's just in charge of injunctions that day. And then the judge has 3 options, I believe. One is just to deny it completely. The second option is to grant a temporary injunction, but then there's a follow-up or a return hearing.
I'll overrule.
And then the third option is what happened in this particular case, is that the judge denied the petition as a temporary injunction, so there wasn't enough evidence in the petition to warrant a temporary injunction, but a hearing was set to review it.
Okay. And when was that hearing set approximately, to your knowledge?
I believe it was originally set for May 8th, but Ms. Benefield made a request to continue that hearing.
Okay, so it was then continued?
It was.
Before the hearing actually happened, did you file any documents on Doug's behalf?
I did. So, well, of course, I filed a notice of appearance in that injunction case. And then we started an entirely separate case. So I filed on Doug's behalf a petition for a parenting plan unconnected with divorce. And so he wanted to establish a parenting plan so that he had really time sharing and decision making for his daughter, because he had none of that up to that point because she was withholding all that information.
And some of the lingo may be familiar to us, but so time sharing, what is that?
I'm sorry. So time sharing is what lay people and a lot of people used to generally call visitation. So it used to have custody, parent had custody, and then another parent had visitation. That was changed, and now in Florida at least, and especially in our circuit, we have parenting plans, which is a comprehensive agreement or an order by the court that lays out all the details of parenting as a not intact family. So the major components are decision making and time sharing schedule. So how often the child spends with each parent.
And you said not connected with a divorce proceeding?
Right.
So I would assume that means it can either be with a divorce proceeding or without.
It can be, and of course it can be also in a paternity case, so parents don't have to be married. But in this case, because they were married, Doug was not initially pursuing a divorce because he hadn't had any contact with Ms. Benefield for a while. His initial
Sustained.
Okay. So initially it was not connected with divorce.
Right, his priority was his daughter.
And you mentioned the injunction case and then your motions. Were they two different case numbers?
They were two different case numbers. So the injunction case number was 2018 DR 1823, and then the new case that I filed for Doug was 2018 DR 2318. Now, they're companion cases, though, so they might be separate cases, but they travel together as companion cases, and they're assigned to the same judge through this unified family court program.
Okay. So when the hearing was set and ultimately heard, were both of those case numbers heard?
Both of the case numbers were heard, but it wasn't our first pleading wasn't the same pleading that was heard at the time of the injunction.
Objection. It's narrative, non-responsive to their question.
Sustained.
So what generally were the allegations in the injunction petition?
Generally, Ms. Benefield was alleging that Doug had been violent toward her. She alleged that he had hit the dog, fired a gun into the ceiling. The biggest allegation was that he was poisoning her and their child in utero with heavy metals.
Okay. When was this hearing finally held?
The hearing was held in two parts, actually. It was July 30th, and then the second part was September 17th.
Not responsive to the question, Your Honor.
Overruled.
And that was the year 2018, correct?
Yes, it was.
Okay. And what judge was this in front of?
It was in front of Diana Moreland.
Okay. And you said it was held on 2 days. Why was it held on 2 different days?
It took a very long time. So
Okay.
both sides had experts, toxicologists, and we had a number of other witnesses appearing. We had,
Objection. Not responsive to the question.
Overruled.
there were also people from the Child Protective Team testifying. And so there were too many hours, and so we couldn't squeeze it all into one day.
Okay. And ultimately, at the end of this, did Judge Moreland make a decision?
At the end of that, she did. There were
sorry.
other decisions along the way, but ultimately she made a decision on the two matters that were set as the companion cases.
And what I meant was on the second hearing day, did she make a decision?
Yes, she
Okay.
did, September 17th.
And what was that decision?
There were two parts because, there was two cases.
Objection, Your Honor, just final decision.
For the prior motion?
Yes.
Yeah. Overruled.
Go ahead.
Thank you. For the injunction, she made a lot of rulings and a lot of findings about lack of evidence and then denied the petition.
We don't want to talk about what went into that. We just want to know what her ruling was.
Okay, she denied the injunction, so
Okay.
that was the first part.
Okay. And then the second part?
The second part was on the parenting plan case, the time-sharing case. And so in that, she entered a ruling for a time-sharing schedule. That would be an introduction schedule because Doug at that point had never met his daughter, and that would increase over time on a temporary basis. And then she entered a ruling that he would have ultimate decision-making authority over the child's medical needs and otherwise shared decision-making.
Overruled.
And otherwise, I'm sorry.
Otherwise shared parent responsibility, which is joint decision-making.
Okay. And as of that day, was Judge Moreland's ruling timed? Like, was it immediate? Was it in the future for the time sharing?
It was immediate. Well, not that day, but she said the first day, and it was just a couple of days later, the 21st, which is when Doug was supposed to meet his daughter for the first time.
Okay. And this time that Doug met his daughter for the first time, were you present?
I was, yes.
And where did this happen?
It happened at Manatee County Sheriff's Department on, I think it's 301.
Did you arrive together or separate with Doug?
Oh, we arrived separately. When I got there, Doug was already there.
And how old approximately was the baby at the time?
I think she was around 6 months old. She was born in March, and this was then the 21st of September. It's about 6 months.
And can you explain how that interaction went? Did you observe it, first of all?
I did.
Okay,
So when I arrived, I got into Doug's truck and we just waited because we were there early. And then he saw Ashley arrive with the baby. And so he pulled the truck closer and then we both got out of the car and started walking toward Ashley. And then it was just an odd kind of interaction, actually. She turned to me with this nasty look on her face and said to Doug,
I'll sustain as to the characterization.
she turned to Doug and said, "Are you dating her?" And so obviously we both said, well, of course not, no. And then I hung back and Doug then was standing there and Ashley approached him with Emerson and they started talking. Eventually she let him hold the baby and they just kept talking for a few minutes. Then I was advised that they were going to be leaving together, strangely, that Ashley was going to be going with them for the time sharing.
Was this a surprise to you?
Absolutely. We had just been in knockdown, drag out litigation for months with just horrendous allegations that were unfounded. And yet she said, "I want to go with you." And he said, "Okay."
Objection to the characterization of the allegations being unfounded and continued editorializing by this witness.
Can we approach?
Sustained.
So when they told you they were going together, what was your response?
I pulled Doug aside and I cautioned him about going with her. I advised, his attorney, and so I did advise him. I said, "This isn't a good idea. She's trying to set you up for something. Don't do this." And he said, "I understand. I'm going to go ahead and do it anyway." And so I stayed and observed as Ashley strapped the car seat into the back of the truck, and she got in the truck with Doug, and then they left together for his first time sharing with his baby.
Okay.
For their baby.
So after this first time sharing, did this seem to start a time of peace, so to speak?
It was a time of peace. Actually, before the 26th, but on the 26th, Doug and Ashley both signed a stipulation that I had drafted at Doug's request, which expanded the time sharing that Judge Moreland had ordered at the hearing on the 17th. So within a week, they had already agreed that he was going to have even more time sharing than Judge Moreland had said.
Okay.
And so that was filed in the court file. It took away the restriction of meeting at the sheriff's office if they chose.
Non-responsive.
Overruled.
So yes, that was the beginning of a time of peace that extended for quite a period of time.
And during this time, well, how long did that last, the peace?
It lasted, to my knowledge, about 11 months.
Okay. And during this 11 months, did you see Doug and Ashley?
I saw them in magazines. Actually, they were attending gala events together, and so they were kind of the...
Speculative and hearsay.
Overruled.
So other than seeing them together at the sheriff's office, I didn't personally observe them out in public, but I did. Like I said, I saw them in various forms of media. They're quite the couple.
Okay. And you said this peace lasted about 11 months. What broke this peace to your knowledge?
Well, it was my understanding from Doug that they were getting ready to move in.
Hearsay.
Let's not talk about what happened with what Doug said was supposed to happen. But during this time, did Ashley stop speaking to him?
I'm sorry, I didn't hear the question.
During this time, did Ashley stop speaking to Doug?
Objection. How would you know it calls for hearsay?
Effect on the listener.
Overruled.
Thank you. They continuously spoke to one another for 11 months until August 16th of 2019.
Objection. I thought that was a yes or no. Objection, non-responsive.
Sustained.
Okay. So around this time, you said November 16th?
August 16th,
August 16th.
of 2019.
Okay. What happened at this time?
Doug was supposed to be moving in with Ashley and her mother, Alicia. He had moved all of his things in.
And we're not going to talk about the specifics of that.
So, counsel, I'm sorry to interrupt. Could I request the instruction from the court about,
Can we not do speaking objection?
Do you need to approach?
Heard anything about it? No. Everybody says no. All right, you may resume your question.
And I believe as we left off, Ashley and Doug were not speaking to each other. Pretty much not speaking to each other.
Right, beginning on August 16th, 2019, they were not speaking to each other.
Okay. And as a result of that, did you ultimately file anything on Doug's behalf?
I ultimately did, yes.
Okay. And what was that?
We filed let me think back, it was so many years ago now, a series of things, but one of the first things that we filed was an amended petition for divorce. And so it was actually a motion for leave to amend with the amended petition attached to it, which is the procedure.
So that ultimately means it was not seeking divorce before, but now the petition is.
Yes, that's correct. And still the parenting plan with some additional allegations, but that's what the main first pleading was.
Okay. And at some point after this was filed, did you get information that there had been complaints filed against Doug Benefield?
Yes, I did. So that amended petition was filed, I think, November 6th or 5th of 2019. And then within a month, I would learn that there was a series of complaints filed with.
object, hearsay?
I'll sustain.
Ultimately, these complaints that were filed against Mr. Benefield, were they documented or filed in any way in your casework, in your cases?
Object, relevance.
I'll overrule.
So, of course, we didn't attach them as exhibits to our next pleading, but we did file an amendment.
Object, editorialized.
Sustained. That would ask for a yes or a no.
Okay.
Can you repeat the question for me?
Those complaints, did they make their way, the information at least, into your filings in your cases?
Yes.
Okay. At some point, did Ashley file an injunction request based on these allegations?
Yes.
Okay. And around this time, was there a psychological evaluation ordered with Dr. Broder?
It was not ordered by the court. There was a psychological evaluation that was put into place through, I believe, the Child Protective
Objection
Team.
editorializing. How many
Sustained.
times?
So an evaluation was recommended.
I sustained it.
Excuse me. I requested an instruction from the court to disregard the last answer.
Members of the jury, I have sustained an objection. When we had our initial instructions, the preliminary instructions on Monday morning, I want to remind you one of those very important instructions. If an objection is made, you're not to guess or speculate as to why it was made. Likewise, you're not to guess or assume or speculate what the answer might have been had the objection not been sustained and the witness had been allowed to answer. So you're to disregard those last answers.
As part of this process
Hold
with,
on. Sufficient?
I'm sorry.
Thank you. Yes, sir.
Go
Sorry.
ahead.
As part of the process of these cases in court, did Ashley and Doug Benefield, to your knowledge, see a Dr. Broder
Yes, they did.
for a psychological evaluation?
Yes.
Okay. Do you know when this petition for injunction filed by Ashley was set for a hearing?
I don't remember the date that it was initially set because she filed a motion to continue.
Objection
Basis?
editorializing, not responsive to the question.
Oh,
Go ahead.
It was continued several times after she filed a motion for mediation, and then eventually it was scheduled to occur, I believe it was September 30th of 2020.
Okay. So you said it was continued several times because of a mediation. So just what is a mediation and how does that play in?
Okay, so mediation is a settlement conference that takes place. It generally involves the parties as well as their attorneys, and then a neutral person who's generally a certified family court mediator. And so what it generally happens is a mediator goes back and forth between each side to try to work out an agreement. And in this case, it was ordered by Judge Moreland in response to Ms. Benefield's motion.
To do the mediation?
Correct.
Okay. And did you participate in the mediation?
I did, of course.
And also Doug and Ashley Benefield?
Yes.
And as a result of that, did some of the focus of the hearing coming up change?
In anticipation of the mediation, yes, the focus of the upcoming hearing on the 30th changed.
Okay. And in what way did that change?
Earlier in September, I think on the 17th, Doug and Ashley signed a joint motion to release the psychological evaluation reports in the divorce case, in the 2018 DR 2318 case. Because in that situation, the psychological evaluations had not been ordered by Judge Moreland. They were put into place through.
Objection, not responsive, editorializing.
I'll sustain on the narrative.
So they did a joint motion to release the psychological evaluation.
Yes.
And is that fairly typical? It's needed in this realm to get that result released to the parties?
Oh, of course.
Objection, relevance, it's what's taken place in this case.
Ooh.
A judge would not just release, is not
Good
able
question,
to.
Tim.
Oh, I'm sorry, Judge. I apologize.
A judge doesn't release that report unless...
The judge orders that it can be released.
Okay. And Doug and Ashley did a joint motion for that to happen.
They did.
And to your knowledge, what was their path forward from that point?
The path that went into place was they were reconciling and moving to
Object
Maryland.
speculation as to what the path forward was.
Ooh.
And so when we were leading up to the week that he was killed, it was agreed upon that they were going to result in an impasse of the mediation because they were reconciling, and then the hearing on the 30th, the week after, was only going to be to release a psychological evaluation report,
Okay.
and they were going to pursue the move to Maryland.
Okay. So ultimately, the only thing that was supposed to happen at this hearing on September 30th was the release of the psychological event.
That was it.
That was it. Okay. And do you recall what day of the week that was, September 30th?
I believe it was Wednesday, so the mediation was a Thursday prior to the killing, and then the hearing was supposed to be Wednesday the 30th.
Okay. And what day was Doug killed?
Sunday night,
And that would be the 27th?
yes.
And who was the judge going to be at this hearing on the 30th?
It was still Diana Moreland. She was still the judge on the case.
And at all times that you dealt with Doug, did he ever seem to you overly angry or aggressive about things?
No, I thought Doug was never angry. He was very mellow and matter of fact. It was a point of contention between us, actually.
Okay. I have no further questions. Thank you.
Thank you.
Cross.
Good morning, Ms. Murphy.
Good morning, Mr. Taylor.
We've met on a few occasions, have we not?
Yes, we have.
And we meet again this morning.
It's lovely to see you.
So your specialty is family court,
Family law, yes.
and you've been practicing family law, I think you've told us, 23 years. You have your own firm, you and your husband.
Yes.
And in that capacity in family law, correct me if I'm wrong, but when you litigate matters in family court, excuse me, there are rules and procedure that apply to family court, are there not?
In all courts, and including family court, yes.
Okay, such as the rules of evidence,
Yes.
the rules of procedure, family court procedure,
Yes.
and ethical obligations as well.
That's correct.
Those always govern your behavior with respect to the tribunal, the court, correct?
All of our behavior, yes, that's correct.
Are you familiar with Florida Bar Rules of Professional Conduct?
Relevance, Judge?
I'll overrule. I don't know where this is going, so I'll overrule for a moment.
Thank you.
I'm familiar.
Yeah, Rule 4-3.3, candor toward the tribunal.
I'm familiar with that rule.
All right. You're familiar with that rule's obligation of a duty to disclose false evidence.
I don't have the rule in front of me, so if you want me to read and see if that's exactly in the rule, I can certainly take a look at it. I'm generally familiar with the obligation to provide candor to the court.
Yes, and to disclose if evidence is inaccurate. I think
Yes,
we can
exactly.
agree on that, correct?
Of course.
That would include, would it not, a failure to correct a materially false statement of fact?
Yes, I'm aware that that exists, but I don't see how that could apply to my case with Doug.
All right, well, let's see. I want to ask you about a sequence of events now relating to the litigation that you mentioned to us between Doug Benefield and Ashley Benefield.
Was this the injunction you're referring to or the divorce case?
I'll be very specific in my questions, if you'll be patient for a moment.
Of course.
Ashley Benefield files her domestic violence petition on April 23rd of 2018. Is that correct?
I believe that date is correct, yes.
Just so there's no mistake, she then correct me if I'm wrong, because you seem to have the dates mastered. Ms. Benefield then files a petition for divorce and temporary TPR on May 31st of 2018.
I don't remember the date that she filed those, but she filed, those would be, I think, separate things. And so in response to the petition for parenting plan unconnected with divorce that I filed on Doug's behalf, she filed an answer and a counter petition seeking divorce.
So your answer for purposes of my question was you don't recall the date.
Yes, that's correct.
Okay.
And it wasn't that she
May I
was...
approach the witness?
Yes.
See if this
Yeah, I really
refreshes
don't
your recollection as to the date.
I need to get my reading glasses, Mr. Taylor.
While you're looking at it, when I refer to the initials TPR, what does that stand for?
Termination of parental rights.
Okay.
Yes, thank you for the reminder. You're right. This is the 31st of May. And she did file a separate case. I had forgotten that.
Well, the question pending was, does that refresh your recollection as to the date?
As to the date, yes. The
Yes.
contents, no.
Was I correct in my statement to you that the date was May 31st, 2018?
Yes.
Now, would you take a look, if you need to refresh your recollection, as to count 2, specifically paragraph 5? Ms. Benefield makes some allegations there, does she not?
She does.
All right. On June 19th of 18, you file Mr. Benefield's answer.
I don't remember that.
May I approach?
Yes.
Let's see if this refreshes your recollection.
Thank you.
Is the date June 19th, 2018?
Yes, that's correct.
All right. And that's your answer, is it not?
This is Doug's answer that I drafted and filed on his behalf.
That
Yes.
you drafted and filed on his
Yes,
behalf.
correct.
And in response to paragraph 5 of Ms. Benefield's petition, you deny it, do you not?
Objection relevance, Judge?
Oh, I think,
I'll overrule on those
yeah,
grounds.
thank you, Judge. Ms. Murphy, my question was, if you would look at paragraph 5, do you enter a denial?
I'm sorry, it's number 5 is 7 pages long, so I was just checking to see if that was correct.
Well,
Yes,
your answer.
we denied these allegations
Okay.
that he committed those acts during pregnancy.
Now, as part of that action, your client, Doug Benefield, submits to a deposition 27 days later on July 17th, 2018, does he not?
I don't remember that exact date, but he did submit to a deposition around that time frame.
Okay, and in that deposition, while,
Pretrial motion.
Sustained.
Your Honor, she opened the door. She's already talked about,
Maybe
Would you like to approach?
yes.
Hope you beat the crowd for lunch. Did anybody discuss the case amongst yourselves with anybody outside of this group? Or did anybody do any research on the people, places, things, or legal topics we've heard anything about?
No sound.
All right, everybody says no. When we broke for lunch, Mr. Taylor was cross-examining Ms. Murphy. You may resume your cross.
Thank you, Judge White. Ms. Murphy, we've pretty much established that the homicide occurred on September 27th of 2020, correct?
That's my understanding, yes.
Okay. And then you've told us here today that Dr. Broder's report was set to be released 3 days later on September 30th. Is that correct?
Yes.
All right. And the inference by you in the state's theory is...
Objection?
So, I'm sorry, Judge, was that overruled?
Overruled.
Thank you. The inference by you and by the state's theory is that Ms. Benefield then killed Mr. Benefield to stop the release of Dr. Broder's report.
Are you asking if that's what I believe, or if that's what the state's inference is?
Well, you've discussed the matter with Ms. O'Donnell, have you not?
I have, yes. Yes, I have.
And in fact, she's provided you with all the documents in the case, hasn't she?
I don't know if she's provided me with everything, but I have gotten a lot of documents in the case.
By direct conversations with Ms. O'Donnell.
Yes, I did a
Okay.
discovery request.
And so is the implication not that, as you testified before the jury earlier, Ms. Benefield shot and killed Mr. Benefield because of this report that was coming out by Dr. Broder 3 days later?
Absolutely, I have no doubt.
Okay, so that's the theory of the homicide.
Right.
All right, so I want to pass you some emails, see if you recognize them.
Should we approach?
Yes.
To pass these documents to you and let you just take a look. Take your time. Okay, so I have a series of simple questions for you. Do you want to reconsider whether or not the release of Dr. Broder's report was set for 3 days following the incident?
It was agreed with,
Do you want to
no, I'm not going to
answer
revisit
it?
that.
You can answer and then explain if you like. I'd like you to first answer.
Okay. I'm not revisiting the answer. My answer is the same. It was set for the 30th, 3 days after,
Okay.
and I can explain further if you want to hear more.
No, that's fine. As long as you've reviewed that, it refreshed your recollection, I trust?
It does. I don't think it's a complete conversations, but yes.
Yeah, okay. Now, is it not a fact that Dr. Broder, on the 3 days following the event, was on vacation?
What event? The murder?
Yes. The 3 days following the event that this report was to be released, is it not a fact that Dr. Broder wasn't in town? He was on vacation.
I don't think that's correct. I think he was on vacation the week prior, but I don't know. I try to remember everyone's vacation, but this was a lot of years ago.
Is that document in front of you contain emails between you and...
Objection? Relevance.
Overruled.
Does that document that you were holding contain emails between you and Judge Moreland's judicial assistant?
As well as other people.
But that's not what I asked you. I asked you, does that document contain emails between you and Judge Moreland's judicial assistant?
Not only, but yes.
All right. And you still maintain, after reviewing that the hearing was set for release of Dr. Broder's report?
Dr. Broder was returning from his vacation on the 23rd. So if you look back through the emails.
Not responsive to my question, Your Honor. She's editorializing. I asked her for a simple answer. She can feel free to explain it after if the court feels that's appropriate.
I'll sustain it. Called for a yes or no.
Well, and that's why I'm saying she's, okay,
No. It called for a yes or no, so
Oh, okay.
your objection,
is sustained. Got it. All right, so is the answer to my question yes?
Can you repeat the question?
I knew you were going to ask me that.
Well, I want to be accurate.
Can I ask the court reporter, Your Honor, to read the last question back?
go ahead, ma'am.
And you still maintain, after reviewing that the hearing was set for release of Dr. Broder's report?
Yes.
Now, could we agree if Dr. Broder was out of town and not available, and the court would not entertain the hearing unless Dr. Broder was present, could we agree that that hearing 3 days later would not take place?
Mr. Taylor, I don't think you read the emails correctly, because the hearing that her assistant was referring to was a hearing to take place on the 23rd when Dr. Broder was not available because he was on vacation. I'm talking about the hearing that was on the 30th when he was available. That was 3 days after your client killed my client.
And it's your testimony then that the hearing would have taken place?
Had he been alive, yes. On the 30th, not the 23rd, which is what I think you're
All right.
confusing.
You referred to a letter that you sent to Ms. Benefield on March 14th, 2018.
My memory is that it was the 15th of March, but if you have it, that would certainly help. And do you have the email that was sent with it?
No.
Okay, this is not the letter that I sent. This is a draft of a letter.
Mm-hmm.
The letter that I sent on the 15th was on my letterhead, so this is not the letter.
Okay. The letter that you did send on the 15th, I think you told us, if I'm not mistaken, was an effort by you on Doug's behalf to advise Ms. Benfield, among other things, that he wanted to try to work things out.
No, I don't think that's correct. No, that's not what I said this morning, nor was it the intention of the letter. And I don't have the actual letter I sent to verify, but there was nothing about reconciliation. The letter was about whether she would agree to him being present for the birth of his child, what was supposed to be the next month.
All right. So you sent the letter to see if she was willing to have him present for the birth of the child.
Yes, that's right.
We're in agreement.
Yes.
All right. Were you aware whether or not there was any prohibition at the time that you sent that letter from Douglas Benefield coming in contact with Ashley Benefield in any capacity?
I'm aware that there was an injunction that was entered by mutual agreements. It was what people refer to as a mutual restraining order out of South Carolina.
Correct. And it was in effect at that time, was it not?
It was. They would have had to have a written agreement modifying that.
So that would have prohibited Mr. Benefield from being present with Miss Benefield, would it have not?
No, I don't have the South Carolina order in front of me, but my recollection.
do.
Oh, that would help if I could see it then.
May I, Your Honor? What is the date of the transcript?
Well, the date of the hearing was November 3rd,
November
2017.
3rd. And you were aware that the order was entered for a period of 6 months, correct?
I wanted to, didn't you hand this to me for me to look at?
Sure.
Okay. Okay.
Okay, so what's the date that the hearing takes place?
The hearing took place on November 3rd, 2017.
And at that hearing, Doug was present.
It appears so, according to the order
All right.
that was entered
And
10
if
days
you-
later.
If you look at the last page, I believe paragraph 2, the judge orders.
I'm going to object to going through this hearsay piece over.
Are we only talking about the order?
Right now, she's looking at the transcript.
No, this is the order.
Okay, the order.
If it's a court order and you're asking the witness to interpret it, I think that's okay. I think she's demonstrated that she has sufficient experience, training, and knowledge.
All right. So the hearing concluded on the 3rd.
It appears that it did. I wasn't there.
Yeah.
This was before my time.
But you were aware of that when you sent the letter to Miss Benefield. In other words, you knew you were sending the letter because Mr. Benefield was not allowed to communicate with Miss Benefield. Wasn't that why you sent the letter?
No, that's not why. Maybe that's why he didn't send her a letter, but that was not the reason why I sent the letter. I sent the letter so that it was a formal request, not in between the two of them directly.
Would you agree that had Douglas Benefield asked that of Miss Benefield, it would have been in violation of that order?
Sustained.
Let me pass to you, if I can, this document.
Did you see it?
I did not. I don't know what
Oh,
that
sure.
I need you to show it to opposing
Yeah.
counsel before you show it to a witness.
I thought she had a copy. Ms. Murphy, is it not a fact that you knew on September 18th of 2000 that the only matter being heard 3 days later on September 20th was the injunction, not the release of Dr. Broder's report?
Now, I think you're getting the dates confused again. So this was September 18th, was this email talking about the judge setting a hearing on September 23rd. Because in this email, she did say the only matter being heard on September 30th is the injunction. That changed after this time. And you don't have those emails, apparently.
Do you?
Well, no, I don't have my file with me. It's 3 boxes worth of documents. But before we even went to mediation, it was agreed and the court was advised that we were going to be addressing only the joint motion for the release of the psychological evaluation.
Which was not said on that day, correct?
You mean the 23rd, which is what they're talking about in this email?
Yes.
Right, it was not said on the 23rd. Dr. Broder was on vacation.
Okay.
It was going to be said on the 30th.
Did you know whether or not Doug Benefield sent a package to Miss Benefield in November of 2017?
I don't remember the date. I know that he did send her a package before this order was signed, but after the hearing took place in South Carolina.
Okay, so after the judge ordered no contact, he sent her a package.
My understanding is that Doug did not really understand what was going on at this hearing. I know Ms. Benefield was even chastised by the court for manipulating that system.
Well, thank
and
you
so-
for adding that. Let me just ask you a question. What is it about you may not contact Ms. Benefield that you think Doug didn't understand? By the way, Doug was there and heard the judge say it, so enlighten us, please. What do you think it was about you may not contact Ms. Benefield that Doug would not have understood?
Doug did not have the court order when he went to buy her birthday present. He told me that the negotiations about this mutual restraining order took place in the hallway outside of the courtroom. But I wasn't there, so that's just what I was told. And we had the time that he received this order from the judge, from his attorney's office, and it was after he sent the package.
Okay, so this report by Broder, the one that you acknowledge and the state suggests is the theory behind the homicide, Ms. Benefield had signed a voluntary agreement to participate in that evaluation, correct? It was not court ordered. Isn't that what you told us?
It was not court ordered in the family law court.
So
I don't
she
know what she signed.
She voluntarily participated.
You know, I don't know. You're going to have to talk to the Manatee County Sheriff's Office because it came out of that office or the CPT office.
Well, you were the lawyer for Mr. Benefield. Was your client ordered to participate?
I don't know that we're in agreement with the word ordered. So when I think of an order, I think that a judge has ordered people to do something. And so we had filed a motion for a psychological evaluation in the family law court. And so if that judge had signed the order, that would have been an order. So my answer is I don't know if either of them were ordered to participate.
You're not aware of any commandment that either Mr. Benefield or Ms. Benefield participate in Dr. Broder's evaluation.
It's my understanding that they were both required to as part of the investigation with the Manatee County Sheriff's Department.
Give me just a minute, Your Honor.
Yes, sir.
All right, one last shot at this.
Can I see the document?
Yes, same document I showed you.
Oh, the same one from before?
Yeah. Does that document have any impact on your position that the release of Dr. Broder's report was scheduled for September 30th?
It was scheduled for September 30th. We knew before the weekend that the hearing on the 30th was going to address the joint motion to release the psychological evaluations. Ms. Brown and I had extensive discussions about that because Ms. Benefield was agreeing to dismiss her petition.
Ms. Murphy, I'm sorry to cut you off. Is the answer to my question no, that it doesn't change your position?
It does not change my position. It was scheduled for the 30th.
Well, when we say scheduled for the 30th, is it not a fact that the only hearing that was to take place on the 30th was everything other than Dr. Broder's report?
If you had...
Is the answer to my, well, let's get a simple answer. Is the answer to that yes?
I don't have the docket, so I guess the answer is I don't know what the docket says. All I know is
You
it was
did not
scheduled for
know.
the 30th.
Objection, Judge Leonard, answer the question.
You trying to make
Finish your
this.
answer.
All I know is that that was supposed to be addressed on the 30th of September.
And were you not told on the 30th September that the only issue that would be heard was the domestic,
and answered.
Overruled.
was the domestic violence injunction? That's what I'm asking you. Is the answer to that yes or no?
Initially, that was what we were told. That was not the case by the time we got to mediation. The situation had changed.
And do you have any documents that you brought here today to support your contention and the state's theory that the release of this report was the incentive for Miss Benefield to kill Douglas Benefield? Do you have any documents that show that that correspondence with the court's judicial assistant was wrong, and that
Compound question?
and that the only matter being heard was not
Compound
Let me finish.
the domestic violence injunction?
Sustained.
Do you have anything that supports that the release of Dr. Broder's report was scheduled for the 30th?
I don't know what documents you got from Ms. O'Donnell's office. However, I did provide
Do
emails.
you have any documents here today?
I didn't bring anything, nor was I asked to.
Okay,
You should
so
have
you
the
knew,
emails.
wait, you knew you were coming to court to testify before the jury in a homicide case,
Badgering.
Go ahead and answer your question.
that the incentive for Miss Benefield to kill her husband was the release of this report on the 30th. You don't have anything to support that other than what you've told us?
Sustained.
That's all.
Don't, sir, you have one more paper. Mr. Taylor, don't forget your paper.
I'd like to approach also after the witness is issued.
All right. Redirect.
No questions, thank you.
Can this witness be released?
Yes.
Absolutely not. She's under our subpoena.
All right. Ma'am, you remain under subpoena. As I said before, same rules on sequestration, so you cannot discuss.